listen-only mode.
Good afternoon. I'm Dr. Jill Brooks from Hearst Healthcare Compliance. Welcome to our noontime webinar. We are happy to have Allyson DiRocco, an attorney from Morris James, joining us today. She will be discussing tips for employers responding to Equal Employment Opportunity Commission charges. Allyson?
Hello, thank you for having me. As Dr. Brooks said, I'm an attorney at Morris James in Wilmington, Delaware, and I represent employers both in the private sector and the public sector. Many of them are in healthcare industries, and a lot of my representation does deal with helping employers respond to EEOC charges, and that's what I will be speaking to you today about. Just to give you an overview of the EEOC and what it does, the EEOC enforces federal laws that make it illegal for an employer to discriminate against a job applicant or an employee because of that employee's race, color, sex, including pregnancy, religion, national origin, age, 40 and older is the age cutoff, disability, and genetic information. The federal laws also deal with retaliation, and it's illegal to retaliate against an individual who complains about discrimination, files a charge of discrimination, or participates in an employment discrimination investigation or lawsuit. So the EEOC enforces those federal laws. Basically what the authority and role of the EEOC that's listed on their website, it just discusses the fact that they investigate charges of discrimination against employers who are covered by the federal laws. They fairly and accurately assess the allegations in the charge of discrimination, and they will make a finding. They will attempt to settle charges where the EEOC finds that discrimination has occurred in the employment setting. That process is called conciliation. And they do have authority to file a lawsuit against the employer if they find a reason to do so. They do not, however, file a lawsuit in all cases where they have found that discrimination has occurred with that one employee who filed a charge. So today I'm going to talk about certain federal laws that apply to private employers. They also apply to public employers, but in a different sense, in that for these federal laws that apply to private employers, it may be with a certain number of employees it applies in a private setting, but different in a public setting. So I'm just going to talk about private employers today. And the main federal law that we'll be discussing today is Title VII of the Civil Rights Act of 1964. And that applies to private employers who have 15 or more employees who have worked for the employer for at least 20 calendar weeks in this year or last year. Another federal law that we'll be discussing is the Age Discrimination in Employment Act, which applies to 20 employers who have 20 employees or more who worked for the employer for at least 20 calendar weeks in this year or last year. Also, there is the Equal Pay Act. We won't be discussing it today, but it's one of the federal statutes that falls under the purview of the EEOC. And then also state discrimination laws apply for even less employees. You'd have to check with your state in your state code. In Delaware, Title 19, Chapter 7 of the Delaware Code applies to private employers with 4 employees or more. So you have to check with an attorney in your state with regards to the state laws. So this slide covers just an overview of the prohibited policies and practices that the federal laws that I discussed previously cover. And basically, as you can see from the list, Discrimination is prohibited in pretty much every aspect of employment. I listed various areas where discrimination and retaliation is prohibited, and I added an asterisk in places where I see the most charges. Just to give you a little bit more information about when an employee files a charge, and for those of you who don't really even know what that means, an employee would have to go to the office of EEOC, or I believe there may even be some online procedures, but when an employee feels that they are being discriminated against in the workplace or retaliated against in the workplace, they go and do what's called as filing a charge of discrimination with the EEOC. Now, they can also at the same time file a dual charge with the office, the Department of Labor in their state. So if, for example, in Delaware, an employee can file a dual charge with the EEOC and the Delaware Department of Labor Office of Anti-Discrimination, and then usually the Department of Labor would take over the investigation. But it just does depend on how the employee files the charge and which agency is going to be doing the investigation. When an employee files a charge of discrimination, there are a few things that the employer should do right from the outset. The obvious thing that most employers don't really realize, but probably should realize, is you can't retaliate against an employee who files a charge of discrimination. So the most obvious things that would be considered retaliation is if an employee files a charge of discrimination, you can't terminate that employee or you can't suspend that employee. Some less obvious adverse employment action in retaliation for filing a charge would be reassigning that employee to a less desirable position or schedule, or excluding that employee from events that might have an impact on the employee's development or advancement, or maybe providing lower performance evaluations. So all of those things are illegal and should not be done to an employee who files a charge of discrimination. The employer should put your insurer on notice. Some employers carry insurance policies that would cover a defense for a charge of discrimination. So you just have to look at the policy and contact your insurer. The employer should conduct an internal investigation when a charge is filed. Look at the relevant documents, look at the policies that are in place, look at the personnel file of the person who filed the charge. Take a look at whether there have been any internal complaints, talk to witnesses, other employees, and counsel can assist with this. We do this on a regular basis with our clients. It's important to keep the information confidential during the investigation at the management level. And document preservation is another important thing that should be done when a charge is filed. So we'll discuss that in more detail later, but the employer should not destroy anything in the employment files. One thing that an employer can do is consider mediation. So when an employee files a charge, the employer will receive notice of the charge and will be instructed that they can either respond by providing a position statement within 20 days, or they can submit the mediation form saying that they're interested in mediation. The employer should consider mediation after the internal investigation. If you notice that there might be some problems and you think that mediation would be in the best interest of the company, that's something to consider. Definitely counsel can help with that decision. The one thing about mediation that is a benefit is these federal statutes provide for attorney's fees for the prevailing party. So if the charging party files a charge of discrimination and prevails, and files a lawsuit and prevails, then they would be entitled to their attorney's fees, which over this long process can be very high. If you consider mediation early on, you're cutting off attorney's fees in the very beginning, and it does lower defense costs, but it's only in certain situations if you think that it's in your best interest. The employer is also going to have to prepare a position statement, and we're going to get into that a little bit more detail later, and respond to the request for information from the EEOC, which is basically a document request. Okay. So it's helpful for employers to have a basic understanding of the legal standard so that that's in the back of the employer's mind when conducting the internal investigation, when talking to counsel, when preparing the position statement. You really could spend all day talking about the legal standard and the case law, but we're not going to do that. I'm just going to give you a brief overview so that when I discuss the position statement, you kind of understand what the key items that you want to submit with a position statement are. So basically, for the Title VII of the Civil Rights Act of 1964, that's what I'm going to focus on. That's the federal law that makes it illegal to discriminate on the basis of sex, race, and as well as the other protected characteristics that I mentioned earlier. So disparate treatment and disparate impact are two theories of discrimination under that Title VII statute. Title VII prohibits employers from treating applicants or employees differently because of their membership in a protected class. Now, a disparate treatment violation is made out when an individual of a protected group is shown to have been singled out and treated less favorably than others similarly situated on the basis of an impermissible criterion under Title VII, such as sex or race. Disparate impact has to do with employment practices that are discriminatory and illegal if they have a disproportionate adverse impact on members of a minority group. So that doctrine applies. It prohibits employers from using a facially neutral employment practice that has an adverse impact on a certain class of people. So if you have a policy that's neutral on its face, but it has a negative impact on, say, African Americans, then that falls under the disparate impact theory. I'm actually going to primarily focus on disparate treatment because that is what I mostly see. And that's what a lot of the charges do deal with. Under the umbrella of disparate treatment, you have cases that involve direct evidence and you have cases that involve indirect evidence. Direct evidence is when an employee says that the employer admitted that the decision was motivated by discriminatory intent or that acted pursuant to a policy that's discriminatory on its face. I mainly see the other type, which is indirect evidence. Indirect evidence is where an employee makes other types of allegations against an employer, such as there was some suspicious timing of things, or that other employees were treated more favorably, and certain conduct that the employee alleges that there's some inference of a discriminatory intent. So I'm focusing on indirect evidence under the disparate treatment category. And the McDonnell-Douglas burden shifting legal analysis is what applies and what we're going to continue to discuss. So under the McDonnell-Douglas analysis, which is named after a Supreme Court case, the charging party, the employee first has the burden to make a prima facie case. So they first have to show that they're a member of a protected class. They have to show, which is, I'm African American or I'm female. So that's the protected class. Then they have to show that they're qualified for the position. So in this situation, I'm discussing, if a person is going for a promotion and they didn't get it, this is what they would have to show. So that they're qualified for the position, that they suffered an adverse employment action. So that they didn't get the position would be an adverse employment action. They didn't get a promotion. And that they're similarly situated employees who were treated more favorably. So, some of their coworkers who are similarly situated to them, someone did get the promotion over them. Then after they prove that prima facie case, then the burden shifts to the employer. And basically all the employer has to do is articulate a legitimate, non-discriminatory reason for whatever action they took. So in a promotion kind of a context, they would say, this employee, the charging party, wasn't promoted because there was a better qualified employee, or that employee who didn't get the job had poor attendance, or there was a discipline issue. They just have to articulate a legitimate, non-discriminatory reason, and then the burden shifts back to the charging party. The charging party then has to demonstrate that the employer's reason was pretext for discrimination, which means that the employee has to show that the employer's reason was false. So as you can see from this analysis that the courts will look at in a federal lawsuit, the plaintiff, the charging party, has the burden in the prima facie case, and then at the end it shifts back to them. So I just give you this as a background. This is for the attorneys to know. You don't have to memorize this or have to have this known verbatim when you're responding to a charge of discrimination. But I just give you this information as a background in responding to a charge. Okay, so next slide has to do with tips for effective position statements. And as I said, when an employee files a charge of discrimination, the employer will have 20 days to respond by either submitting the position statement or sending the form in for mediation. We're usually called in by clients at this point to assist with the preparing of a position statement. I definitely do not advise employer clients to do nothing when they receive a charge. A position statement is a detailed summary of the pertinent facts and the legal position concerning the charge. But you have to remember that the EEOC investigators, the ones who are reading the position statements, they're usually not attorneys. So they definitely have experience, but they're not necessarily attorneys. So in my experience, when we assist clients in responding to a charge, we actually do more work on the front load and with the investigation and spend a decent amount of time working on the charge or responding to the charge in the position statement, because it's more helpful in the long run, because the charge may get dismissed by the EEOC early on, and then the employer won't have to endure a full investigation. So the employer will look at the allegations in the charge, collect data, investigate, interview, and determine what happened, who was involved, and who are the decision makers. They'll collect statements by witnesses, people who directly observe the conduct by the employee, and that kind of thing. You may or may not, when you're going to have to send in statements from key witnesses, and you have the option of having those be affidavits. I don't generally recommend submitting a sworn statement. In these kinds of situations, you have to keep in mind it is testimony under oath. So in the event that there is a lawsuit down the road, that statement, an affidavit, which is testimony under oath, can be used against that witness on cross-examination if there was a lawsuit. So usually we just do witness statements. So I'm going to describe for you some tips for making effective arguments in the position statement. First, you want to describe the employment history of the charging party. Just give background information, the makeup of the department, job description, things like that. Then you want to describe any company policies or procedures that are applicable. And you might want to describe the demographics of the department. And then you want to keep that McDonnell-Douglas framework in mind that we discussed earlier. And you want to mention if that person's saying that they're a member of a protected class, just verify that they really are. In a promotion kind of a situation, I'm using that as an example, was that person really qualified for the promotion? In one case I had, there was an employee who filed a charge of discrimination for failure to receive a promotion, and he wasn't qualified. For example, the requirements in order to get the promotion were that he had to have 3 years where he needed a certain rating on an employment review, and he did not. So those were the reasons that he wasn't promoted. He wasn't qualified. You want to spell this out in the position statement. And then you also want to be able to explain whether there was actually adverse employment action. So adverse employment action, there's a legal definition for it, which means that it's a significant change in employment status. Hiring, firing, failure to promote, reassignment with significantly different responsibilities, or a decision causing a significant change in benefits. Not getting a promotion, being terminated, not getting hired, those are obvious adverse employment actions. But there are times when employees will make an allegation that actually don't amount to an adverse employment action under the legal definition. For example, I found case law in certain jurisdictions where a lateral transfer is not adverse employment action, even though that'll be alleged by the charging party, or a written reprimand is not adverse employment action in certain cases that I've found. So the next thing you want to focus upon are, were similarly situated employees treated differently than the charging party? So we'll look at other people and compare them to the charging party. In one example case that I've had, there was an African American employee who was suspended without pay for sleeping on the job, and he claimed that other employees were treated more favorably when they engaged in the same conduct. However, in fact, when we went through the personnel files and looked at the discipline, there was a Caucasian employee that had actually received a more harsh punishment for the same behavior. So it just didn't add up, and there were the allegation that similarly situated employees were treated differently. In that situation, it was not helpful to the charging party. And then, as I described, the employer wants to describe the legitimate, non-discriminatory reason for whatever action they took. So the employer wants to just to give their reason. Why wasn't this charging party promoted? Why was this person terminated? Why was this person not hired? So in an example case, a teacher was terminated because there were no longer enough students who were interested in taking class, so the class could no longer be filled. That was the reason. Or there was another case I had where there was an employee who was suspended because she spoke inappropriately to customers. So that's an obvious reason why someone would be suspended. Or an employee who didn't get a promotion because there were other employees who deserved it more. So also in position statements, you have to talk about the bad facts. So if there are bad facts, you just have to do the best that you can with them and give the best explanation you can. And then in conclusion, in the position statement, you want to request that the charge be dismissed and state that the company acted fairly. In addition to submitting a position statement to the EEOC. The EEOC is also going to respond to have a request for information, an RFI, and you're going to have to also respond to that. And it depends on the type of charge, but the EEOC will have a list of documents that they're requesting you to submit along with the position statement. So some of the documents that are requested may include, the personnel file of the charging party, and similarly situated employees, written statements from decision makers, documented reprimands, oral reprimands if they were documented, evaluations. That's why it is important to write accurate evaluations, and if something needs to be noted, be sure to note it, because those can be helpful to your position or hurtful. Job postings, the EEOC may ask for job postings. Interview notes regarding candidates, it's also important to save those because a lot of times it's hard to rely on memory, and interview notes can be very helpful. And correspondence, letters of interest, policies and procedures, those are all things that the EEOC may request. And when I do prepare a position statement, I normally reference most of these types of documents in my position statement, and I will attach them as exhibits. For example, if the employee is terminated, I would reference the progressive discipline that led up to the termination, and I would reference the policy that the employee violated, and I would attach those. So you can do that also. And if the request for information does seem like it's too broad, you can talk to the investigator about narrowing the scope. That's definitely reasonable. So I just quickly go through if you have a investigation by the EEOC, obviously you want to be very cooperative with the investigator. You want to be prepared. You want to prepare witnesses beforehand, make sure that the managers aren't caught off guard, and those kinds of things. For the location of the witness interviews, you can have it near an entrance so that the investigator's not walking all through the building. Those are some tips. And sometimes an EEOC investigation might be on site, but it also could be over the phone, and you would get a list of people that they're going to talk to over the phone, or a list of the people they're going to meet with in person beforehand. Employer can be present during interviews with management personnel, but the investigator can do an interview of non-management employees without the employer's presence or permission. Attorneys are permitted to be in any of the interviews, and usually it's fine with the EEOC investigator. And it does allow the attorney, although you can't object to questions or anything, or stop the interview, but you can take notes, and then if something needs to be submitted supplementally to the EEOC, that's sometimes helpful. So in the EEOC charge handling process, according to the EEOC, it takes about 182 days to investigate a charge. And we just got the fiscal year 2013 enforcement and litigation data. Retaliation's the most frequently cited type of charge, followed by race discrimination, sex discrimination, and disability discrimination. And we went through, some of these on this slide, but I've described mediation to you, that's an option, and that's when you can get together and possibly settle. It could be dismissed right after they receive the position statement. You can have, it could get to the investigation stage if there's not dismissed after the submission of position statement. The EEOC can subpoena documents, and then at the end of this, the EEOC can issue a notice of right to sue. So if the EEOC finds that there is no discrimination, they'll issue the charging party a notice of right to sue, which does allow that charging party to go and file a lawsuit in federal court. If the EEOC determines that there is discrimination, they can either decide to file their own lawsuit against the employer, and they can also go into the conciliation phase, which is where the EEOC tries to attempts to have the parties settle. I discussed this previously just briefly, but there are some record keeping requirements and the preservation of documents, and this is pretty straightforward, so I won't read it. But the other thing that we do is when a charge is filed, we as attorneys usually tell the employer that we issue a litigation hold letter, which will tell them that not to destroy any pertinent documents. And that will help later if there is a lawsuit, so that the relevant documents have been preserved and maintained. And just as a summary to this presentation, there's no way to prevent an employee from filing a charge of discrimination or to know if an employee will file a charge. But just some best practices: to have the proper employment policies in place, update the policies as the laws change, follow the policies and have training, keep proper documentation, and investigate if an incident arises. So that's my information that I have in responding to a charge.
Thank you, Allyson. Thank you for joining us today. This was very helpful information on the EEOC. And the contact information is now on the screen for Allyson DiRocco. And feel free to contact her at her email address. And you can also contact First Healthcare Compliance. Thank you.
The organizer has ended the session, and this call will be